The Uganda we want. So mu Uganda gye twagala mu lutalo luno olw'okulwanyisa obulabbayo obukenuzi nze kyempita obuvundu. Munna Uganda alina okuba nga yeenyigiramu.
Ffenna twenyigire mu lutalo.
Ate abalala tebasomye kuzimba wabula bayize okuzimba.
Uganda gye twagala okulaba ng'enguudo zonna nkole nungi, public transport nga weeri.
Kati eno gavumenti eriwo erina akabonero ka Lucifer. Buli kyotunulako mu Uganda kiriko oxygen. Either babika amawulire malungi oba mawulire mabi. Minisita teyeetagisa kabangali budde buno zaki.
At this time, why should somebody import furniture from outside Uganda? Let us leave NRM to be in charge for another 36 years or more.
I really want to see a Uganda that believes in the rule of law. If you have a constitution in place, follow it to the letter. Don't change laws just because you want them to favor you.
Kuba njagala omanye nti obugagga bwonna Uganda bwe yeeyagaliramu buyita waffe ku ttaka lyaffe. Naye busoga mugidibaze.
How can a referral hospital refer you to a private clinic? The Uganda we want buli muntu ateekwa okumanya nti I am a stakeholder, nkwatibwako si kwesuulirayo gwa naggamba.
Uganda oyinza okukakana nga mwe mulina bagraduates aba university nga bangi okusinga ebungereza. Mwe mufokasinga nnyo ku degree. Eri bo bafokasinga nnyo nti byensomye mbijeemu omulimu n'enkola.
We are dreaming of a Uganda where at a young age there is such a relationship between parent and son, parent and daughter, where the daughter can say this is what I want.
Uganda gye twagala empya tesobola kubeerawo nga tewali mateeka. Amateeka agakola.
The Uganda we want. Wano ku Dream TV. Welcome to the program, The Uganda We Want. My name is Robert Mulanzi, and today we have Professor Kanyeihamba'S George Wilson, who is going to speak to us and will give us his opinions or his views on the Uganda he wants to see. Thank you for listening to us on Impact FM and for watching us on Dream TV. Let's welcome Professor Kanyeihamba'S Wilson.
I was Minister of Justice and Attorney General in two governments. First, in the Yusuf Rule government that overthrew Idi Amin, and then later under President Museveni, who is currently our president. I was also first Minister of Commerce, and then I became a Minister of Justice and Attorney General. And then the first ever presidential advisor against President Museveni. And while I was a member of the legislature, I was elected by my district now, Rwanda, and became a delegate in the Constituent Assembly, where I was elected more or less unanimously by all the delegates to become the chairman of the Legal and Drafting Committee that made our 1995 Constitution, which is the supreme law of this country, even as I speak. Then in 1997, I was appointed a judge of the Supreme Court, and the first Supreme Court created under the new Constitution of 1995 Supreme Law. And I worked as a judge for more than 10 years. And some of the leading judgments, I either gave the lead judgment or participated in their judgments or decisions. They include the Attorney General versus Tinyefuza, now Tifosa, the Amira properties, where we established the principle that an ordinary citizen or company can sue the government, since the government has a reciprocal right to sue citizens for failing to pay tax. That was established for the first time. I also participated in the leading findings and decisions of challenging presidential elections. We've had 4 in Uganda. The first one was in 2001. Since the adoption of our constitution in 1995, many experts regarded that not as a precedent because there were only 5 judges sitting instead of the constitutional quorum of 7. And therefore it lacked the necessary constitutional quorum. So it is not a big authority. The most leading authority on presidential elections in which I had the honor to serve was the 2006 presidential election. It's very, very interesting, and I have revisited our decisions in a new book, small booklet, called Presidential Elections, Challenging a Presidential Election Act. In this book, I maintain that all presidential election petition, so-called judgments, are unconstitutional.
You're maintaining that?
Yes.
Why?
If you look at Article 104, it provides that, and it is headed Challenging Presidential Elections, and says that if there is a petition challenging a presidential election, the petition shall be filed in the Supreme Court within 10 days of the election. I want you to remember that.
Within 10 days of the election.
Of the election. Well, after the declaration of the election, it must be filed within 10 days. So if we have
an election,
yes. If so today they declare the result of the election, you have 10 days
to file a petition.
To file. The court may give you permission to file out of time for circumstances beyond your condition, but that is rare. Now, when the petition has been filed, Article 104 of the Constitution is again very clear. The judges of the Supreme Court shall inquire into the petition. Not here.
But
inquire into.
What is the difference?
Where a court is obliged to inquire, it takes initiative. The initiative is in the judges to say, although the petitioner says this, is it true? The respondent says that. Can we find evidence to support that? Or is there some other evidence which neither party has produced, which we can use to determine the election? In other words, in an inquiry, the judges take initiative. I recently held a press conference jointly with Professor Lumumba of Kenya, a very renowned constitutional lawyer. And he agreed with me that the Uganda Supreme Court has been making it wrong. You don't just sit around as a judge or as a court and wait for the petitioner to prove his case, presumably beyond the reasonable doubt, or wait for the respondents to say the election was free and fair. You, the judges, must look at the evidence. You initiate.
You come out.
You come out.
So,
as we did in 2006. That's why the 2006 is a very good precedent. For another reason I am going to tell you. But the main one is that we followed the Constitution. We carried out inquiry into the petition. We did not rely entirely on the evidence adduced by the petitioner or his witnesses, or alternatively, the evidence produced by the respondents or their witnesses. No. We carried out our own investigation. This little book explains exactly what we did and what happened. In fact, I was going to fall into the trap of what most judges have done in all these petitions and sit back and let the parties prove their case or disapprove it. Then the late Justice Mlenga, who was my colleague on the court, called me here one night. He said, Professor Kanyeihamba, I heard you say you are going to dismiss the petition. I said, yes. He said, history will never forgive us if we dismiss that petition. He said, this is, a petition is not an ordinary case. You don't hear it like you hear a criminal or civil case. The judges must take initiative into finding out the whole truth. And he reminded me that when we were debating this provision in the Constituent Assembly, which took us about a day and a half, everybody said, in a petition, the petitioner and his witness are anxious to uphold the decision. Therefore, they tend to exaggerate their winnings and they minimize the mistakes that were made. The respondents on the other side also wanted to win. They want to say the election was not free or fair. So they also exaggerate. Any evidence which is against them, they are reluctant to reproduce it. So that is why the onus of showing that a petition, whether an election is free or fair, is on the judges themselves.
It comes back to them because they are the ones who are going to make the judgment.
Absolutely.
Okay.
And for that reason, therefore, that is why we avoided the word, you shall hear a petition, or you shall give judgment. Those words are missing in Article 104. we say the judges shall inquire into the petition and give their findings.
The judges.
Yes, the judges. Not judgment. The words here or judgment do not appear in Article 104. My problem with Ugandans and the journalists in particular, why haven't we ever challenged it? Either the Chief Justice or member of the jury. Why do you use the words here
Not inquire.
when the delegates and the Constitution speaks of inquiry? Why do you say we are giving our judgment? Where do you get that word?
Not our findings.
Not our findings. Now, let me tell you why the 2006 presidential election is only valid and leading authority. There, we inquired into the petition as the Constitution requires, Article 104. Then we gave our findings.
In 2006.
Yes. Findings are different from order or decision.
Because you make a decision
yes,
after the findings.
After findings. So what did we find? We asked ourselves 5 questions, which the Chief Justice read for the whole world to know. The first question was, did the 2006 presidential election, the other elections, comply with the Constitution? And the answer was unanimous. 7-0, we were 7 judges. No, it did not comply.
You all said no.
That is our first finding, yes.
On the first question.
On the first question. On the second question was the laws applicable, which was the Electoral Commission Act or the Presidential Election Act. These 2 were they complied with?
The Electoral Commission Act and the Presidential Election Act.
Were they complied with? Again, we were unanimous. 7-0. No, they were not complied with. I want the listener really to understand me fully. Then came the third question. Was the election free and fair?
Big question there.
That was the question, third question. The 7 of us said no. 7-0, we all said no, it was not free or fair. Because, why? Fourth question. The army and the police interfered in the electoral process. Consequently, it was not free. Answer, no. How many? 7-0. Our findings. Then finally,
the last question.
Last question. Was there vote buying, vote stuffing, and vote cheating? 7-0 of us. Yes, there was. There was vote cheating. There was rigging. 7-0, yes. Then came the final, which was not based on findings or inquiry, but on personal opinion. And that is what is in this.
Personal opinion. So,
although your findings are X, Y, Z on all those questions, did it make any difference to the result? That really is a terrible question. In 2006, I think 3 of us, the late Justice Odell, the late Justice Sekoko, and me, Kanyeihamba, we said, yes, it made a difference.
The other 4 said,
no, wait.
I'm anxious to hear what the
Then
other
we
4
were
said.
joined by 2 others who also said, yes, it made a difference. The late Justice Mulenga and the late Justice Karokola. So there were 5 of us, 5 out of 7, who said it made a difference and the election should be cancelled and we hold another one. When we first met, that is what decision we made. The Chief Justice then, he's still alive, Ben Kodochi, summarized our decision. He said, by 5-2, the election, rather the petition succeeds, and there will be another one within 30 days. They asked Chigundu, who was the chairman of the Electoral Commission, can you manage it? He said, yes, we are ready for a new election. Museveni also said, if they nullify it and I am defeated, I accept the defeat. All those were said at the time. Then later, when we were left with about 2 weeks to announce our findings, one of us, Justice Karokola, in a meeting in the Chief Justice's office, asked, but can we guarantee that if we nullify this election,
will be successful?
Yeah, the army will accept it. If their leader, whether their boss, the commander-in-chief loses, do you think the army will accept? We say that is a political problem. We are judges. It will be answered politically. In any case, Chigundu has said there is no problem, and the President Museveni, who is the commander-in-chief, has said there is no problem. You will accept the
You'll be okay
result.
with the results.
So it's unfortunate I'm the one still alive, or one under Dochi and the Katulebe, who were on that team. I wish that just Karoko was still alive. So we said, he said, for me, I have changed my mind. I will dismiss the petition. But at that time, we understood his reasoning, although we didn't agree with it. It was a political reasoning. We are judges discussing legal issues. So we knew that we were going to dismiss, or rather to allow the petition by 4-3, because one of us had moved to the other side. Then came that day of giving our findings and order.
I am with Professor George Kanyeihamba. He was a former justice in the Supreme Court of Uganda. He is a Ugandan author. He has done quite a lot.
Yes.
Start from there. On the final day now.
On the final day,
Yes.
which was almost a year since we had the petition, for me, I was ready to give my findings within 30 days of the petition being filed. But the others said they were not ready. And they had the reason for saying they were not ready. They had written long long speeches and opinions they called judgments.
Not findings.
No. In each of them, they say, my judgment, my judgment. I don't know where they got the word from. Because it is not reflected, it is not written at all in Article 104. Please get a copy. I want everybody to get challenging presidential election by Kanyeihamba. It's just a monograph. It's on one subject only, presidential elections. So, as we were standing up to go and in court to read our findings, one of us, and I describe what happened, whispered to the Chief Justice. And the Chief Justice said, let us sit once again and reconsider our opinions, because this is a very, very grave and important decision we are making. At this last minute, let's reconfirm what we are doing. I have that like a photograph in my mind. He went by seniority. He first asked Justice Odell, Arthur Odell, what is your opinion? Allow the petition. He went to the second one, who was Justice Sekoko. What is your opinion? Allow the petition. The next one was Karokola, Alfred. What is your opinion? Because of what he had told us earlier, dismiss
the petition.
The petition. Remember he said, do you think the army will accept if we see Museveni lost? Then he asked the next one, who had been with us all along, Joseph Mulenga. Joseph Mulenga said, dismiss
the petition.
Actually, everybody was shocked, because all along he was saying he will allow the petition.
This last minute, he says,
that was as we were waiting to go to court to give our finding. That's when he changed. Then the other judge was Kanyeihamba, me. I maintained my position
that allow
the petition. The final one, before the Chief Justice said what his mind was Justice Bart Katurebe. He was the juniorest of all of us. And obviously, for him and the then Chief Justice, they never changed their mind. They always said dismiss, regardless of what evidence was presented. At one time, one of them, actually Bart Katurebe, said he can never conceive any situation where he could judge against President Museveni. Those are his words. He's still alive. He and
he
Kavuma.
Said so like that. He said so like that.
Yes, like that. So he said, and because of that, I dismissed the petition. And he did. I had been consistent. He and Odochi had been consistent. It is only Mulenga and the late Karokola who changed
their mind on the last minute.
So the Chief Justice said, in that case, I have to change my formulation. Instead of allowing the petition, we are dismissing it by 4 judges to 3. Remember, we were reduced to 3 now, from 5, and they were now 4. So that is how the petition in 2006 was dismissed.
Is that the picture?
Legally, we all found unanimously that there was a fault with the petition, rather with the election, but politically. And we don't have much time. I will tell you how those two were persuaded to change their mind. Persuasion in quotes. Threatened.
So, Professor, should we say that because we are looking at the Uganda we want, now in the Uganda we want, should we continue with that, as you say, the political persuasion into the judges?
No.
How should that continue? And if not,
it should not. It is criminal.
How are we going to? How can we avoid
Can
that?
you please read this booklet? It is called Challenging Presidential Election.
I am going to read, but
I want to tell you. And it only costs 20,000 shillings. Just for the expenses we used. In this here, I am challenging the 11th Parliament, which is current. And the opposition should listen to me. Take up the challenge in this little booklet and what's the word? Table a motion.
On the floor of Parliament.
Yes. To delete paragraph A of clause 6 of section 59 of the Presidential Election Act. Because it is illegal, we are talking about a religious program, it is iniquitous, and it was put there by bribery. It is not even in the Constitution. Paragraph A of subsection 6 of section 59 of the Presidential Elections Act 2005. If you remember, in 2005,
the discussion that was going on about the term.
Yes,
about the
term limit. They removed term limits from the Constitution in 2005. More or less at the same time, they were persuaded to insert paragraph A, subsection 6 of section 59 of the Presidential Election Act, which is not legal, which some of our colleagues in 2006 used to support the order that the winning candidate won. It has nothing to do with the law or with legal authority. It is an intimidation. You read in this book that those of us who stayed on the side of allowing questioned one or two of our colleagues. We said, had Museveni been Amin, and similarly, he had won the election, court declared the winner. Would you have upheld the winning or not? Unanimous this time, all of us. No. You ask, what is the rationality of saying, had the winner been Idi Amin, our decision would have been unanimous. We would have allowed the petition. That question is answered here. So, what is the issue?
And looking at the Uganda we want, especially in that line of the Constitution.
The Uganda we want, therefore, is a Uganda where the kind of machinization that has taken place under the NRM party doesn't occur. where judges are not intimidated to find as the government wants.
So when the judges are intimidated, the professor, I want to know, and I want to, that's why I'm asking, is it a must that they should allow the intimidation? Can't they resist the intimidation?
I agree with you. They should resist it. And I tell you, I give you a very vivid example. Before Dolo became Chief Justice, President Museveni had been looking for an alternative to Ben Odochi, who was Chief Justice. And he renominated Odochi, the retiring Chief Justice, who had become 70, to become Chief Justice again. I and Gerard Karuhanga and another lawyer, Chiza, we challenged reappointment on the grounds that a retired Chief Justice is not qualified to be reappointed a Chief Justice again. We were upheld both by the Court of Appeal, acting as a constitutional court, and by the Supreme Court, especially the Supreme Court. And then my colleagues asked, why didn't Justice Odochi, whom we respect, has been a very fair, good Chief Justice, when President Museveni called him and said, I want you to be Chief Justice again, Odochi, knowing he was not qualified, why didn't he tell him, Mr. President, I am not qualified to be a Chief Justice. Look for another one. The same, I'm told, applies today. And I am challenging the place. A friend of mine, we used to dine together when he was still in government, civil service, is Richard Abutel. Richard Abutel is now claimed to be the Deputy Chief Justice. But the Judicial Service Commission did not recommend him. The President, having appointed Doro Winyi as Chief Justice, simply also announced that I also appoint Richard Buteyo, Deputy Chief Justice, without an input or recommendation from the Judicial Service Commission. Our Constitution is very, very clear. It says only the Judicial Service Commission shall nominate candidates. Either
be appointed.
Appointed.
To be appointed.
So it seems that for some time now, the President has been bypassing that provision. So for me, all many of the judges who are serving, unless they were nominated by the Judicial Service Commission first, and the President appointed them, they are there illegally. All of them. You media are also to blame. XYZ have been appointed judges by the President, but they never tell you they've been nominated. I was nominated together with Justice Mulenga, Justice Arach, and Justice Tino Mujuni, among others. Our names were published on nomination. I remember William Pike of New Vision challenging Justice Mulenga or mine qualifications. You say they are fine men, but can they make good judges? Before the president appointed us. And that's how it should be. That's the Uganda I want. That's how we follow the law, we follow the constitution. And nobody is appointed by the president unless it has been recommended by the relevant body.
So the recommendation has to come from the Uganda Judicial Commission.
Yes.
They say we have these judges.
Yes.
They are qualified to do this job. Now you have the opportunity
yes.
to appoint.
The only thing that the presidency does, and he doesn't personally, is when they say we are nominating Kanyeihamba to be a judge. Yeah. That is the role purely, exclusively of the Judicial Service Commission. Then the role Museveni has is to investigate in my background, because he has got the means of whether I am suitable, whether I am a crook, and so that is his role. But he has no power whatsoever to nominate anybody to become judge.
Professor, we've got to keep it here for today.
Right.
So if you've been listening keenly, you've heard Professor Kanyeihamba George giving out his view on the Uganda that he wants to see and probably he wants to live in, and for you to live in. If you're listening to us on Impact FM, or if you're viewing us on Dream or watching us on Dream TV, we're, of course, tomorrow...
But I want to disagree with you there, Robert.
Where?
What I have been giving is not my view. It is the true position of our constitution. It is the exposition by the constitutional law.
Because tomorrow we are going to talk about if the constitution of Uganda still makes sense.
Yes.
We are going to talk about that tomorrow. But for today, your view, of course, has been welcomed by the viewers and me who is interviewing you, because you're saying that if it is, let's say, a nomination or appointing of judges,
yes,
it has to come from the Uganda Judicial Commission.
Yes.
And secondly, if we are, hearing the election petition, let's say petitions, we have to follow the order, and the judges must come in to inquire.
Yes.
Not to
hear.
Not to hear.
Because what here is not in the Article 104.
They have to inquire.
Yes.
Because why did we shift from that? Why did we shift from inquiring to hearing?
To hearing. Who invented that? In Article 104.
I'm asking you. I'm asking you.
Nobody. It is a fraud.
Oh.
It is fraudulent. Ask any judge, including the Chief Justice today, my friend. Where did the judges get the word hear or judgment in Article 104? They are not there. They invented them in order to shield the winner.
Oh, the main purpose is to shield the winner?
Yes.
Not avoiding costs?
No.
I thought they were trying maybe to avoid the costs. If they,
no,
if they are going to inquire.
Shield the winner.
Oh.
And connected to Parliament refused to pass the term limit. Rather, term limit thing.
Thank you so much, Professor Kanyeihamba, for today. Well, the Uganda we want continues tomorrow. Please join us, same time, same presenter. We'll be here. Thank you so much for being part of this show.
Thank you very much, Ruben.
You're welcome. The Uganda we want. So mu Uganda gye twagala mu lutalo luno olw'okulwanyisa obulabbayo obukenuzi nze kyempita obuvundu. Munna Uganda alina okuba nga yeenyigiramu.
Ffenna twenyigire mu lutalo.
Ate abalala tebasomye kuzimba wabula bayize okuzimba.
Uganda gye twagala okulaba ng'enguudo zonna nkole nnungi public transport nga weeri.
Kati eno gavumenti eriwo erina akabonero ka Lucifer. Buli kyotunulako mu Uganda kiriko oxygen. Either babika amawulire malungi oba mawulire mabi. Minisita teyeetagisa kabangali budde buno zaki.
At this time, why should somebody import furniture from outside Uganda? Let us leave NRM to be in charge for another 36 years or more.
I really want to see a Uganda that believes in the rule of law. If you have a constitution in place, follow it to the letter. Don't change laws just because you want them to favor you.
Kuba njagala omanye nti obugagga bwonna Uganda bwe yeeyagaliramu buyita waffe ku ttaka lyaffe. Naye Busoga mugidibaze.
How can a referral hospital refer you to a private clinic? The Uganda we want buli muntu ateekwa okumanya nti I am a stakeholder, nkwatibwako si kwesuulirayo gwa naggamba.
Uganda oyinza okukakana nga mwe muyina bagraduates aba university nga bangi okusinga e Bungereza. Mwe mufokasinga nnyo ku degree. Eri bo bafokasinga nnyo nti byensomye mbijeemu omulimu n'enkola.
We are dreaming of a Uganda where at a young age there is such a relationship between parent and son, parent and daughter, where the daughter can say this is what I want.
Uganda gye twagala empya tesobola kubeerawo nga tewali mateeka. Amateeka agakola.
The Uganda we want. Wano ku Dream TV